The dangerous philosophy of monopoly of state violence. Giving the state more power only erodes the natural rights of citizens. James O'Keefe of the O'Keefe Media Group recently released undercover recordings of Jason Beck, an associate director in the Office of the Secretary of Defense. Mr. Beck stated his wide-ranging opinions on the role of the government and his political philosophy in the undercover recordings. Most alarmingly, he wants to use his position to reform the U.S. government, including that the U.S. needs to embrace and implement the philosophy of monopoly of state violence. The theory of state monopoly of violence was debated prior to and during the Enlightenment, but has reemerged in political philosophy after World War I and the formation of the administrative state by sociologist Max Weber. The idea, though promoted by Mr. Weber and by other political leaders in the U.S. government, is incompatible with the U.S. Constitution and the rights of the individuals as set forth in the Bill of Rights. The United States Constitution was debated and written in the Age of Enlightenment and codifies those Western influences of the period. The Constitution, through the Bill of Rights, codifies the rights of the individual and the relationship of citizenry with the government as envisioned in the Declaration of Independence. Individuals are granted the unalienable rights of life, liberty, and the pursuit of happiness, and the government is created to protect those rights. The philosophy of the founding is that the limited government belongs to the people and not the other way around. Citizens are not subjects. The focus on this article going forward is over the philosophy of state monopoly on violence and its incompatibility with constitutional guarantees of inalienable rights and the rights of the individual. Inalienable rights, as stated by Thomas Jefferson, are rights which are held by all individuals by the fact of their very existence and are rights that should not be infringed upon by any legitimate government. This is also referred to as natural rights. These rights include freedom of religion, freedom of speech, press, petition the government, assembly, and the freedom of privacy from unwarranted and unwanted government intrusion. These rights restrain the government, requiring due process of law and equality of all people before the law. These rights are guaranteed in the Bill of Rights of the U.S. Constitution. The Second Amendment of the Constitution lies in the middle ground where some consider it an inalienable right, but others view it not as an inalienable right, but as a safeguard against the government or individuals from taking away a person's inalienable right through the threats or coercion. The Second Amendment defends an individual's inalienable rights of life, liberty, and pursuit of happiness, so life has to be defended, and thus the right to keep and bear arms is an inalienable right by protecting life. Or, if the Second Amendment is not an inalienable right in itself, the existence of an armed population makes it the guarantor of inalienable rights in the Constitution. So it appears the placement of the Second Amendment in the Bill of Rights was an intentional decision that has the gravity of the other rights guaranteed in the Constitution. The political philosophy of the state having monopoly on violence is that only the legitimate state can use force, including lethal force, and is the supreme authority on the use of force. Sociologist Max Weber is largely credited with this philosophy as he states that it is the key to modern public law. Weber formed his opinion through the observations of human characteristics and their apparent tendency to be prone to aggressiveness and violence when left to their own nature, where the individual serves as their own judge, jury, and executioner. Weber logically argues that the civil society cannot operate in such a way, and that this individual tendency of violence needs to be transferred to the state to create and maintain an orderly society. Thus, the individual must give up his power and give it exclusively to the state. The logic of Weber is apparent to most in modern societies where violence should not be allowed in an orderly and productive society to reign. The arguments of human nature and aggressiveness are not necessarily wrong, because even in the most repressive state, individual violence towards others does exist. The question is, how is this concept of the state having a monopoly on violence coexist with the inalienable/natural rights that are guaranteed in the U.S. Constitution? This is where Mr. Weber's logic breaks down in the context with the U.S. guarantees of rights. Robert Leiter writing for Antonin Scalia Law School for George Mason University, addresses this question of state monopoly of violence and the U.S. Constitution. Mr. Leiter argues that legitimate use of force is decentralized in the U.S. between the government, jurisdictions, and the individuals, and that it is important that decentralization remains in place for three reasons. First is that despite the use of professional police forces, the law is under-enforced. Decentralization of force to the individual is important because it mitigates the under-enforcement issue. If law were enforced at appropriate levels where individuals were not needed to solve the enforcement issue, then it would mean more police, overcriminalization, and a threat to other inalienable guarantees in the Constitution due to over-policing. The second is that American law has created a mismatch between the duty of public duties of the government and the private rights of the individual. Leiter argues that law enforcement is a public duty but is not a private right. This means that individuals have no right to claim that the government enforces the laws or protects them. This has been ruled by the U.S. Supreme Court in DeShaney versus Winnebago County Department of Social Services in 1989 and Castle Rock versus Gonzales in 2005, both of which affirm that police have no duty to protect individuals. The result is that individuals or private security addresses this gap in public duty and individual rights. The third reason is that even if the government were granted the monopoly on the use of violence, it is composed of individuals who are agents who themselves have different talents and flaws and thus are subject to malfeasance even when acting as agents of the government. As agents of the government, what happens when the executive authority, which has a monopoly on violence, chooses to ignore the law through choice or malfeasance and allow citizens to become victims who will have no recourse of self-defense, and if they do choose to defend themselves, they will be subject to punishment by the state, who is the only one that can legally use force. The same logic applies to judges and prosecutors who choose selective prosecution based on ignorance, political philosophy, or personal bias. Agents of the government, even when trying to act in good faith, may have to answer to an executive or judicial branch who are not acting in good faith or by mistaken assumptions. Decentralizing and not monopolizing protects the individual's guaranteed rights. The abhorrent philosophy espoused by Jason Beck, who brags in the undercover recordings, is that he is in a position of authority to influence others to adopt his philosophy of giving the federal government the monopoly on violence. Mr. Beck states that his idea is to strip away the Second Amendment rights in the Constitution by force, if necessary, by using the National Guard in the same way it was used to enforce desegregation of public schools. However, in this case, it will be used for weapons confiscation under the threat of force, assumed lethal force, if necessary, to establish the government's monopoly on the use of force and violence. Mr. Beck states that the U.S. Supreme Court will need to be packed with sympathetic justices who will make these actions legal. This, of course, assumes that the new justices will not have fidelity to the Constitution, but an anti-ethical political philosophy that is means-based. After the Second Amendment is made inert by a packed Supreme Court, what does it happen to the rest of the rights guaranteed by the Constitution? There will no longer be any recourse to contest the government with its new philosophy of absolute control of violence. The federal government can use force to coerce individuals, or it can use selective enforcement and prosecution to steer lawless elements to intimidate the citizenry into compliance if they attempt to demand their own rights. It can be assumed that under-enforcement will be an issue even in a monopoly, as economic laws of scarcity do not go away, nor does aggressive and violent human nature go away just by announcing a monopoly. So it will be assumed that politically connected and powerful will have the preponderance of resources for protecting them and their assets. The remainder of those resources will use to be threatened violence to coerce and ensure compliance of the citizenry, with the citizenry becoming more subject than citizen. Mr. Beck took an oath to uphold and defend the Constitution of the United States and not to use the powers of office to subvert the Constitution and strip away rights, including the Second Amendment that protects those rights. People like Beck do have First Amendment rights of espousing their opinions, but they do not have the right to use their position in government to take away the rights of others. People like Beck need to be fired, and if not fired, exposed for who they are and impeached and convicted by the legislative branch. This will ensure that the rights of individuals are not taken away by such ideologues in the government positions who themselves demand for a more powerful state that they will surely subvert for their own purposes.